Good morning, everybody. My name is Makgatu Motshekga. I will be your program director for today. Ladies and gentlemen, you are warmly welcome to the Symposium on Land Heritage and Human Rights, which is co-hosted by the Community Law Center, the University of Pretoria, and the Nelson Mandela Metropolitan University. I would especially welcome Ambassador Marissa Jarrett of the Embassy of the Kingdom of the Netherlands, Professor Quinton Johnson, Principal of the Nelson Mandela University George Campus in the Southern Cape, Professor Bongani Majola, Chair of the South African Human Rights Commission, Advocate Lex Makua, Member of the Johannesburg Bar, Professor Mathole Motshekga, Chair of the Parliamentary Portfolio Committee on Justice and Correctional Services, Judge Johan van der Westhuizen, Inspecting Judge of the Judicial Inspectorate of Correctional Services, Professor Frans Viljoen, University of Pretoria at the Center for Human Rights, and all guests gathered here this morning. Can we call upon Professor Quinton Johnson, who will do the opening for us. And welcome. Thanks. Professor Quinton Johnson, as convener, is the principal of the Nelson Mandela Metropolitan University George Campus in the Southern Cape. He is an accomplished academic who received his education from the Universities of Cape Town, Western Cape, and Harvard. Specializing in science, medicine, and business, Johnson received the degree MSc cum laude and a PhD and the GenCorps Medal for Research Excellence from the South African Academy for the Advancement of Science. He has spent his professional life in university as an academic professor, department chair, center, and institute director. He has published widely in peer-reviewed international journals, whilst his book on indigenous medicines was published in Norway, where it won an academic prize for the best illustrated text. He continues to teach and undertake advanced research as an extraordinary professor at the universities in France, while recently having been appointed as a UNESCO ICRO full member of the council. He has raised significant multinational funding for education, research, as well as advancement, and has extensive experience in leadership strategy, administration, and corporate governance.
Good morning, ladies and gentlemen. It is indeed a great pleasure for me to be here and add my warmest welcome, and also to comply with the protocol that has been observed. This is an exciting time where we gather here the brightest legal and political and academic and community minds to engage with an extremely important matter on land and heritage and human rights. We are heirs to an unlikely democracy, as we know. Our history has been calibrated by more than 300 years' worth of colonialism and apartheid, which set us on a course to conflict and near destruction. Fortunately, in 1994, we had our first democratic elections, and that resurrected the possibility for South Africans to dream again, to be hopeful again, to be united again. And since 1994, as we all know, we have made very good strides. We have also seen that there are challenges that remain, very complex challenges. We now more latterly see, especially, the demand for access to land and the accelerated redistribution of land. And what we wish to do is to ensure that there is enabling legislation that will allow us, within the rule of law and within the framework of our Constitution, to redistribute land effectively and efficiently. The 1913 Land Act, as we know, created an incredible pain in our country. In fact, when we think about our history and we look towards the future, it certainly should be a cry that we must indeed accelerate access to the land lawfully. We must certainly reclaim our heritage, and we must certainly restore the dignity of our people. And without doubt, we should promote and advance human and people's rights. Just last year, Prof. Majola, worked very successfully with the South African Human Rights Commission, as well as the Kara Heritage Institute and the Nelson Mandela Metropolitan University, to engage in social dialogue. We think this is quite important, that we speak with one another, about radical ideas, but that those radical ideas must be placed within a rational framework to advance our country together. We must all be in. It can't be that only some have a bright future. It must be that all South Africans can look forward to a bright future. And so we discussed in a race and power dialogue the matter of the Khoisan, the issue of land and language, history and heritage, and of course social cohesion. I don't have to tell you the challenges that we are experiencing in South Africa at the moment with fragmentation, societal fragmentation, and limited social cohesion, which threatens our still emerging democracy. And it is symposia of this nature that will help us to overcome that chasm of inequality, not only through engagement and discussion, but through dedicated and devoted action that is predicated on the reclamation of our heritage and the restoration of our dignity. And obviously, access to land and the redistribution of land within the confines of our Constitution. I am especially glad to see the young people from the universities who have come here to help explain to us what your ideas are as well. You are the future. And from where I stand, the future looks great. We are very hopeful because of you. We are very hopeful because of your intellectual bandwidth. We are very hopeful because of your creativity and your imagination. We are very hopeful because of your determination and your will to succeed, not only for yourself, but for your communities and for the country and the world at large. We are speaking today across a vast cross-section of sectors. We have academics, we have politicians, we have community leaders, we have legal scholars, we have postgraduate and other specialist students, we have folks that are especially dedicated to ensuring that we close this vast canyon of inequality in our social space. It is quite clear, Archbishop Thabo Makgoba just recently said, we should perhaps have the next CODESA on land and the economy. This, no doubt, is a clarion call, which I think many will share. For we wish to preempt and we wish to prevent the reality that has played out in other parts of the world, where people who are frustrated because they do not have access, rightful and lawful access to land, act beyond the borders of the law by invading land and occupying land illegally. In South Africa, we don't want this. And thus these engagements are so critical in order for us to prevent that kind of potential reality. We want South Africa to have a bright future. We can. We have all the resources. We have all the natural talent. We have fantastic infrastructure. And might I say, especially strong universities that, as you know, have come under threat of late. And it's been intense. As a principal of the university, I must tell you, I never trained to engage in these matters. But there we are, all of us as leaders in that higher education space, engaging from the classroom to the boardroom via the streets on our campus, the roads that may be blocked because young people are making a clarion call. Young people that have a majestic quest and a noble cause to have quality education. And that's very important to us. We have also said to young people, we certainly hear you, and we wish to action this together with all stakeholders, because the university is a theatre of expression, but these challenges are of a macro nature that must involve all of us. And so we see government moving towards bringing and helping to bring solutions together with many stakeholders. We applaud that, and we ask that more of that should be done to help ensure that we have the brightest minds of tomorrow accessing higher education and succeeding in higher education. The road will be long. The challenges will be steep. But with resolve in our hearts and an eye towards the future, we will rise to meet our destiny. Of this I am certain. These are just a few words to help set the context of the discussions today that are to come. I, for one, cannot wait to engage and to listen and to find a common way for us to act and to act together. And as the students in the university say, Professor, the university processes are quite labyrinthian. It takes so long for things to get done. We are urgent. We need solutions now. And so it is with the matter at hand. These are complex and vexing challenges which we can and must resolve, and we should do that as speedily as is possible within the rule of law. I just want to recognize our partners who have put all of this together and say a special word of thanks to our program director as director of the Community Law Center at Kara Heritage Institute, and to our director of the Center of, is that you, Frans? I see you there, of Human Rights at the University of Pretoria. And to all that have made this possible in a short space of time. I thank you very much indeed. And just to say to you, just yesterday there was quite a significant challenge, and I was speaking to Professor Bongani. You know, there was a big building in Braamfontein that was burning, and they were challenged. But despite that challenge, he was working on his keynote address to us this morning. And that's how determined the professor is to be here. And that's how determined many of you are, all of you are, to be here. I thank you very much for coming. I know that we will have sparkling engagement. And I'm just going to ask Ambassador Gerard if she would kindly, as a partner from the Dutch Embassy, please bring some words of encouragement and well wishes to our symposium. Please warmly welcome Ambassador Gerard.
Shall I just join you there?
Yeah.
Yes. Thank you so much. Thank you so much. Yes, thank you so much. My name is Marissa Gerards. I'm the ambassador of the Netherlands, and it's really an honor for us to team up with you, to team up to give attention to this very, very important subject, the subject of our time. Let me not go into the subject. I think Professor Johnson did that so eloquently, picturing us the context. But let me tell you why we're teaming up. We're teaming up because we really believe in your initiative, and we really believe in dialogue. Because we think through dialogue you can solve almost every subject or every problem that we have in our time. And I especially believe in this conference because what you do is you try to foster dialogue between different disciplines as well. Because you have people from the political part but also from the academic part of life, and I think that's very important. What I really hope is that today you will end up formulating good ideas, ways forward, and that you can feed in those ideas into the debate, and that we can somehow make sure that the decision makers are aware of your ideas, and to see if we can take small steps, but still small steps. In the end, you will reach, I think, a solution. So thank you so much. I will just leave it there. Wish you lots of success today. I'm looking forward to the outcome. Unfortunately, I cannot be here the whole day, but my staff will be. And, well, let's team up and let's see if we can find some part of the solution. Thank you.
Thank you, Professor Johnson Quinton. Thank you to the Ambassador for that opening. It is now my pleasure to introduce Professor Bongani Majola, who will deliver a keynote address. Bongani Majola is the current chair of the South African Human Rights Commission. He did his studies in law at the University of Zululand, obtaining a public service law diploma, a public service senior certificate, and an LLB degree. Furthermore, he earned the LLM degree at Harvard. He was an academic at the University of Bophuthatswana, later becoming professor and dean of the law of the University of the North. He spent time as visiting professor at the School of Advanced International Studies at Johns Hopkins University in Washington, and as a research fellow at Yale University. He is an advocate of the High Court of South Africa, an academic, human rights scholar, and the previous Assistant Secretary General of the United Nations International Criminal Tribunal for Rwanda. Majola's experience with criminal trials started in Mandadeni when he was appointed the District Court Magistrate. After his academic career, Majola was appointed the National Director of the Legal Resources Center, which is a non-profit public interest law organization that defends the poor and marginalized people of South Africa. He also served as a legal advisor to the Theme Committee 3 of the South African Constitutional Assembly, which was responsible for drafting the Constitution of South Africa. Can we please welcome Professor Bongani?
Thank you, Program Director. Your Excellency the Ambassador, the Chairperson of the Portfolio Committee, Judge van der Westhuizen, distinguished professors and academics, students, ladies and gentlemen, thank you very much for the opportunity. I must just state it as a way of disclosure that the fire was not in my building, it was in the building next door, and therefore that I have no excuse whatsoever to make out of the fire, except that perhaps because of the smoke my voice may be a little bit unusual, but sometimes it is unusual. I'd like to also introduce a member of the South African Human Rights Commission who is here with me, Dr. Fola Adeleke at the back there, and to welcome him here. But I'd also like my secondary school principal to welcome those who are not here. It is a privilege indeed today to speak at this event. I have been asked to comment on the impact of Section 25 of the Constitution, which protects the right to property and other enabling legislation on human rights. In recent times, the focus of social debate in our country has centered on the issue of the right to property in the context of expropriation as a form of deprivation without compensation, particularly in relation to land reform and the urgent need for socio-economic transformation. These sentiments have indeed been echoed by the President in his State of the Nation address, and more recently, that is last month, when he stated that if necessary, the Constitution should be amended so that land can be expropriated without compensation. Consequently, I want to frame my presentation today on the considerations for a human rights-based approach to expropriation and compensation. I must say that my view in the end is that there is no need to amend the Constitution, and that I wouldn't encourage expropriation without compensation. It's the summary of my message. The right to property is a fundamental human right under our Constitution as well as under regional and international law. The Universal Declaration of Human Rights recognizes that everyone has the right to own property and that no one shall be arbitrarily deprived of his or her property. Furthermore, the African Charter on Human and People's Rights provides that the right to property shall be guaranteed and may only be encroached upon in the interest of public need or in the general interest of the community and in accordance with the provisions of appropriate laws. The content of the right to property must be understood in context and in light of the necessity to redress the global historical discrimination, especially in this country. Perhaps it is for this reason that the right to property is also recognized in the Convention on the Elimination of All Forms of Racial Discrimination, which recognizes that everybody has the right to equality before the law without distinction as to race, color, and national or ethnic origin, including the right to own property alone as well as in association with others, and the right to inherit. The right to inherit is indeed important in the context of indigenous practices and the equal treatment of women in regard to property ownership, which the Convention on the Elimination of All Forms of Discrimination against Women also recognizes. While the formulation of the right to property in the South African Constitution is consistent with the legal designs regionally and globally, as I have articulated, it is important to understand the origins of the right to property in South Africa and how we arrived at the present formulation in the 1996 Constitution. The issue of constitutionally protected property rights was one of the most contested areas of deliberation at the multi-party negotiation forum leading up to the establishment of the Constitutional Assembly in the early 1990s. Excuse me. The ruling party at the time, the Nationalist Party, sought to ensure the inclusion of the right to property in the Constitution, while the African National Congress was opposed to the inclusion of this right, arguing that provisions for property rights are best suited in national legislation. There was concern that entrenching the right might handicap the efforts of a democratic government in trying to reverse the effects of decades of racially discriminatory practices regarding land, especially, including dispossession without compensation that had been so endemic under the successive apartheid regimes. Excuse me. It is fair to say, therefore, that the contestation for what should go into the content of the right to property cannot be separated from the history of South Africa, where patterns of land ownership were a direct result of racial discriminatory laws and were heavily skewed in favor of the white minority. Accordingly, it was no surprise that the National Party had a vested interest in ensuring that the right to property was protected in the Constitution, given that such protections would fundamentally safeguard the land rights of existing landholders, regardless of how such rights had been acquired and regardless of whatever laws were later adopted by a new ANC-led democratic government. The protection of the right to property is important for the realization of other rights, such as the right to dignity, the right to food, and social security. in written submissions to the Constitutional Assembly, the Land Research Project of the Center for Applied Legal Studies at Wits University submitted that the inclusion of property rights in the Constitution was inconsistent with international developments because it would compromise even the most basic and uncontroversial land reform measures. And the narrow scope of expropriation of land as provided for in the property clause would constrain land redistribution objectives, and that the legitimacy of property rights as a human rights vehicle aimed at addressing past injustices whilst simultaneously protecting the rights of existing landowners may be eroded, given that its inclusion effectively protects existing and unequal disparities. Understandably, this position was disputed by existing landowners at the time, who argued that expropriation should not be used as a means of achieving land reform. Consequently, the content of Section 25 of the South African Constitution was the result of a negotiated agreement where the right to property is protected but nevertheless permits expropriation for a public purpose or in the public interest, though subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected or decided or approved by a court of law. This section, that is Section 25, thus sits at the heart of an inevitable tension between the interests of the wealthy and those of the previously disadvantaged. And that tension is likely to occupy us for many years to come in the process of undertaking the difficult task of seeking to achieve the equal distribution of land and wealth to all. It is important to note that the method of compensation is not based solely on the market value of the property, but on the basis of a just and equitable payment, which includes 5 considerations such as the current use of the property, the history of the acquisition and use of the property, the market value of the property, the extent of direct state investment and subsidy in the acquisition and beneficial capital improvement of the property, and the purpose of the expropriation. I think the considerations listed under Section 25 of the Constitution reflect the intention of the Constitution drafters to ensure that the government is not, for example, restricted or does not find it prohibitively expensive to expropriate land in the interest of land reform due to the need to pay exorbitant compensation. This position has been affirmed by constitutional law academics who have suggested that expropriation within the current framing of Section 25 may be interpreted to mean that the government can, given certain consideration, unilaterally terminate for public use or public purposes all the entitlements of particular property rights holders. Section 25 offers a prominent place for the courts to determine the amount, time, and manner of payment of expropriation. Consequently, the emerging case law on the right to property in South Africa, which I discuss later in this paper, has focused heavily on the question of appropriate compensation for expropriation. For example, in the Constitutional Court case of Agri South Africa versus Minister of Mineral Resources, where the court dealt with expropriation of minerals in the context of the Mineral and Petroleum Resources Development Act, the court provided a significant shift on the understanding of expropriation under South African law. The court held that the approach to be adopted in interpreting Section 25 with particular reference to expropriation is to have regard to the special role that this section has to play in facilitating the fulfillment of the country's nation building and reconciliation responsibilities by recognizing the need to open up economic opportunities to all in the country. The court also added that we must, therefore, interpret Section 25 with due regard to the gross inequality in relation to wealth and land distribution in the country. In terms of our jurisprudence, it does not seem that in paying compensation, the state should be bound to pay market-based compensation. In the case of Detroit versus Minister of Transport, the Constitutional Court held that viewed in the context of our social and political history, questions of expropriation and compensation are matters of acute socio-economic concern and could not have been left to be determined solely by market forces. It also said that when determining compensation, the factors listed in the Constitution must be adhered to and balanced, with no one factor weighing more than the other. These cases imply that the consideration of what compensation is appropriate in cases of expropriation to achieve land reform has been left to the discretion of the state. This discretion is to be exercised taking into account the factors listed in the Constitution, which, if diligently applied through principles of the rule of law, can in fact legitimately allow the state to expropriate property with limited compensation or without compensation in some cases. Central to the formula in determining compensation is that both public interest and the interest of those affected must be considered, and a just and equitable balance between the two must be struck. Accordingly, in Msiza versus Director General, Department of Rural Development and Land Reform, the court stated that compensation which is below market value can be constitutional, provided it is just and equitable. This is subject to agreement between the parties and based on approval by a court. When interpreting the importance of the history of the acquisition and use of the property, the court stated that under certain circumstances, it would be unfair to pay the full market value as compensation, because an owner could be benefiting twice. According to the court, the requirement to consider the history of the acquisition and use of the property is a very specific inquiry based on the facts of each case. The rationale for requirement is clear, given South Africa's history of land dispossession and racial discrimination. In particular, this factor is most relevant in cases where land was expropriated by the state and sold below market value during apartheid time, or made available to white farmers below the market value. In such an instance, it would indeed be unfair to pay full market value in compensation, as this would enable the owner to benefit twice from apartheid. Consequently, South African courts have accepted that the market value of a property being expropriated is not the only consideration in determining compensation. If market value was the primary consideration, land reform would be extremely expensive for the government and would mean the government will be unable to provide equitable redress to the dispossessed black majority in terms of Section 25. As at 31 March 2016, the government reported that it had already spent almost 20 billion on the acquisition of land for the purposes of restitution, and 94% of claimants of the 143,720,000 new claims that have been lodged since the reopening of the new claims process in 2014 have indicated a preference for their claims being settled through payment of compensation. This trend suggests a number of possibilities that need to be backed up with more research. It could suggest that people do not necessarily want access to land. because financial compensation is more lucrative. Alternatively, it could also suggest that people do not want access to land because they do not have the skills or financial capital to put land to use for purposes such as farming. Furthermore, as suggested in previous submissions of the South African Human Rights Commission, some of the land that has been acquired by government in the past is not viable for farming. It may be possible for the government to expropriate land with limited compensation, or arguably without compensation in certain instances. The groundwork for this has been laid out in Section 25(8) of the Constitution, which provides that, and I quote, excuse me, no provision of this section may impede the state from taking legislative and other measures to achieve land, water, and related reform in order to redress the results of past racial discrimination, provided that any departure from the provisions of this section is in accordance with Section 36(1) of the Constitution, which is the limiting clause. A reasonable interpretation of Section 25(8) therefore suggests that if government were to pass a law that provides for expropriation without compensation, while this will be a departure from the provision for just and equitable compensation, that law would be valid, provided it satisfies the requirements of Section 36 as a law of general application, and is a reasonable and justifiable limitation of the right to property, taking into account the 5 factors listed in Section 36. It is important for any proposed expropriation law to lay out constitutionally entrenched principles on what should constitute compensation for land reform, in order to discard earlier court rulings such as the decisions in Mhlanganisweni, where Geldenhuys J. had suggested that land reform in a public interest does not rank superior to any other legitimate purpose for which property may be expropriated, and the determination of compensation in cases of land reform must not be different. It is interesting to note that in some isolated cases, the courts have suggested, as in the case of Ntlabate versus Field, that expropriation without compensation might be possible in certain circumstances if the infringement is minimal to the owner's rights. Excuse me. Also in Serole versus Pinar, the court ruled that there can be circumstances where the absence of a right to compensation on expropriation is reasonable and justifiable and in the public interest. The court also found this to be justifiable under Section 36 of the Constitution. Admittedly, the Ntlabate and Serole cases dealt with expropriation in the context of deprivation of land for burial purposes. But it remains to be seen whether this principle can also apply in land expropriation for land reform purposes. I'm of the view, however, that compensation must be paid when property is expropriated. This is consistent with international law, and it is important to note that expropriation of property should take place in accordance with South Africa's constitutional requirements in order to avoid unintended consequences. The poorly executed land reform program of Zimbabwe is a case in point. In the SADC tribunal case of Mike Campbell versus Zimbabwe, the lawfulness of the acquisition of agricultural land without compensation by the government of Zimbabwe was challenged. The tribunal held that there is an existing obligation under international law for the payment of compensation. It further held that Zimbabwe cannot rely on its national law, including its constitution, to avoid the payment of compensation. The court found Zimbabwe liable for the payment of compensation under international law, and also found Zimbabwe's land reform program to be racially discriminatory for targeting white minorities. The individual right to property should be placed in a social context, as the court in the Agri South Africa decision has ruled, to move towards a transformative approach, and government must find a balance in ensuring individuals do not unfairly shoulder the burden of expropriation, but society will likewise not be held accountable for compensation at full market value in the instances where it is not justified. It is not only Parliament that has the responsibility to provide legislative guidance on the application of Section 25, but courts also have a role to play on the appropriate interpretation of Section 25 under the constitutional dispensation. Aside from Parliament and the court, an important burden also lies with the government on how to address bureaucratic bottlenecks that stifle the rapid implementation of land reform. To address the challenges of the slow pace of land reform in South Africa, it is important for the government to bear in mind that compensation need not be construed in terms of financial compensation only. The Property Valuation Act of 2014 was enacted to address the valuation of property for land reform purposes. The Act references the constitutional factors to consider in terms of compensation, but defines the factor of market value in terms of willing buyer, willing seller. Consequently, the state needs to embark on processes to determine how to satisfy the constitutional imperative of justice and equitability, such as offering resettlement in some cases without resorting to financial compensation in all cases. This is important because the slow pace of land reform and redistribution has also been attributed to the state's commitment to the willing buyer, willing seller principle and the unwillingness to expropriate land at less than market value compensation. In many instances, bureaucratic obstacles have prevented the land reform program of government. In the South African Human Rights Commission 2013 hearing report to investigate the systematic challenges affecting the land restitution process in South Africa, the Commission noted that the obstacles identified in relation to the slow pace of land reform do not appear to stem from constitutional provisions and accompanying legal framework to any significant degree. The Commission is of the view that in order to address and remedy land restitution processes, it is necessary to deal with the challenges identified from the last 25 years of experience and not depend on legislative changes that fail to address issues of bureaucracy. Excuse me. In general, the Commission has been of the view that the Constitution and related legislation are adequate in providing a human rights-based approach to land restitution. The Commission has also stated in its previous reports that it is necessary for government to acquire land and institute approaches that can effectively redistribute it to the landless. Where ownership is doubtlessly legitimate, the government should compensate landowners for the required land. End quote. Ultimately, the Commission believes that systematic challenges affecting the land redistribution process may be partly due to political problems that require political solutions. In conclusion, while some courts may have opened the door for the possibility of expropriation without compensation, it is important to note that at a comparative and international level, just and fair compensation is required for expropriation. In various jurisdictions, including in Africa, Asia, North America, expropriation based on the principle of just compensation is recognized. Also, while the Constitution provides a pathway for the development of a law that can allow expropriation with limited compensation to achieve the objective to redress the results of past discrimination, the preamble to the Constitution reminds us that South Africa belongs to all of us who live in it, united in our diversity. Section 233 of the Constitution also provides that the interpretation of South Africa's laws must be consistent with international law. Given the decision of the SADC tribunal in the Campbell case that there is a duty under international law to pay compensation, the Commission recommends that the state adheres to our constitutional values of offering limited compensation in cases of expropriation while achieving the objective of land reform. Thank you for listening.